Thank you everyone for joining for this webinar this morning. And it's always interesting and exciting for me to talk about this topic um, in whatever formats. So thanks again. Let's now get into the matter for the day. So I'm going to talk a little bit about the evolution of privacy and data protection legislation. While this is a phenomena, you can pretty much that these days, but we are going to be more focused on Asia in this discussion, and also we will view that topic from the context of HR and payroll. As HR and payroll practitioners, what are the watchouts, or what does it mean with the recent changes in privacy and data protection legislation in Asia? So let's start with something that is fairly basic. What is privacy? And perhaps this question would have been answered very differently some years back, but nowadays governments are really recognizing, and not just recognizing, perhaps they have always been recognizing, but taking active steps to really view privacy as a fundamental human right. And I mean, it goes without questioning that in the modern world, everybody expects that the right of freedom, or right of being left alone, is quite a fundamental human right. So this means that humans should have the right to be free from interference and intrusion, and also they should be able to associate freely with whomever they want. And last but not the least, they should be able to control who can see or use information about them. So that is the whole idea of privacy at a very, I would say, as a vision, or at a philosophical level. And the legislation and privacy acts, which are kind of constantly evolving due to various reasons and stimulants, like the advancement of technology, the evolution of internet, smartphones in everybody's hands, etc., to kind of drive this as the underlying fundamental human right. And everything else in a privacy act is generally the ways and means of achieving this fundamental human right. So when we talk about privacy, another term that we cannot practically separate from privacy, the concept of privacy, is basically personal information or personal data. In fact, a lot of privacy related legislations are even called personal data protection acts in many countries. So that's a term which is quite interchangeably used to imply the same concept. So what is it? So personal information, generally speaking, is information or an opinion about an individual that could identify that particular individual. And it can be the name of the person, it can be just the phone numbers, or their photographs, addresses, or their details like date of birth, or their records generated, etc., etc. And I think one of the key things for HR and payroll professionals to understand here, especially from an HR perspective, is the word that it could be also an opinion, not only specific data elements, but it could also be an opinion about an individual. Why is that significant? Because in HR, there are a lot of processes that involves forming opinions about individuals, or using their opinions. So, for example, as part of a hiring process, a candidate may be screened. There may be background verification done on candidates. They may be screened through interviews, etc. And a lot of opinions will be, in addition to the personal data, a lot of opinions will be generated as part of this process. And strictly speaking, in the scope of privacy acts, in a lot of instances, such opinions can be treated as personal information. And the interesting thing there is that these opinions, these opinions, they need not be really true. As long as it can reasonably identify an individual, it would still be treated as personal information, even if it is not necessarily true. Now, there is another type of personal information, or we can say a subclass of personal information, which are generally treated more strictly under various data protection acts, which is called sensitive information or sensitive personal information, which is again personal information that includes some sensitive aspects about individuals, like their ethnic origins or their political opinions or membership in trade unions, etc., or their religious beliefs they have, health related information, criminal records, and some elements of the biometric information, etc., can be treated as sensitive information by various privacy laws. Now, when we look at it, what is common on both sides of this slide? It's the etc., right? And which means that this is not really an exhaustive list of all personal and sensitive information data elements, but more of a broad definition and some examples. The examples are quite broad, but then you will have to apply these definition in the context of the data that is being collected within each organization to truly find out what would be the extent of personal information or what would be the extent of sensitive information that is collected for the HR process in that organization. Now, if we understand this concept, we will also look at some key privacy terms that will help us all, regardless of our prior experience with privacy related topics and matters, will help us all to understand the concepts discussed further in this presentation today. So let's start with the simpler ones. So the data subject. So who is a data subject? If I want to sound legal, read out what is there, which says an identified or identifiable natural person. Or in other words, this is basically, in common terms, it's a human being whose personal data is being obtained and used. And if we move on to the next one, we have a data controller. A data controller is a party who actually determines the purposes and means of collecting and processing the personal data. Now, that may sound a little bit of a technical definition, but I think it will become easier when I read the next term and give examples on both. So the next term is a data processor, which is a party who actually processes the personal information on behalf of a data controller. Now, a word of caution, data controller and data processor are terms that you can find in many privacy acts across the world, but they are not used in all privacy acts in the world. So it's quite possible, if you are focusing on one country in Asia, that the legislation in that country doesn't use these terms. But collectively, what they mean is that any party who determines the purposes and means of the processing and carries out that processing respectively. Some privacy acts may deal them as like in one set of requirements. Some privacy acts have separate requirements for both. Now, examples. Think of a scenario where an organization is outsourcing something like a recruitment process to a third party. So what information needs to be collected and how it is collected, what process will happen on the collected information, etc., is actually determined by the organization which is outsourcing recruitment process. But then the actual process may be done by the outsourced service provider based on the terms and conditions as stipulated by the customer in this instance. So that's an example of how a data control and data processor relationship works, but there is a lot of overlap. You may see that there are sometimes joint controllers where the purpose and means are determined by jointly by two entities. There can be somebody who is performing both roles together, etc., etc. While these are in a way, you can argue that these are legal jargon, but it's very important to understand these two distinct roles, even if the privacy law or act doesn't differentiate them that way in your country. The next one, we're going to talk about processing, right? And processing is, as obvious it sounds, it is a set of activities that is performed on the personal data or groups of personal data. Now, when we say processing, we may literally think that it is only when you practically do something with the data or make use of the data. But the catch there is that a lot of privacy acts will clearly say that storing of personal information is considered as processing under the privacy law, which means that even an organization which merely stores, like a data center provider, which merely stores information for its customers and does not even have access to that information, can be in the scope of or can be termed as processing the personal information in the finest level of details. Now, third party, a very important term to understand. If there is an outsourcing activity and under the direct authority or a subcontracting activity done by an outsourced provider, that party would be called as a third party in a lot of privacy laws or a similar term. Right. So in the example I gave before, let's say a customer is outsourcing, a company is outsourcing their recruitment activities into a contractor, and they have another contractor who performs certain on the ground activities in a different country. That would be a third party if there is personal data exchange and processing on behalf of the controller or processor done by that party. Right. So that's an example of a third party. Next, privacy officer. He is the poor fellow who is responsible for a company's data protection and strategy and its implementation to ensure compliance with privacy requirements. While I was definitely trying to be funny when I said poor fellow, but then that could really mean something, because there are a lot of privacy acts, or at least there is one that I am quite familiar with in the region that has criminal penalties uh, on on the provisions, or like on consequences of not complying to the privacy acts, like gross negligence, etc. So a key role, and that person's ability to kind of direct the organization and give the strategy and enact it would help any organization a lot in complying to the privacy law requirements. Then the last term is profiling, right? I sort of deliberately included this term profiling in the slide, even though it may not be as rudimentary a term like the others here. Uh, the reason is that today's HR processes emphasize so much on HR analytics, and a lot of it is done by modern HR and payroll products. A lot of times as a USP for these products. But there may also be automated processes for HR analytics, as an entire industry is nowadays built around robotic process automation. And executives are increasingly relying on the power of HR analytics in decision making. So profiling is any form of automated processing of personal data consisting used to evaluate certain personal aspect of natural persons. So it may be behavior of a group of people, it may be performance of a group of people, anything that kind of forms an opinion, or kind of comes up with evaluating behavior of natural persons in an automated fashion can be termed as profiling. And the modern privacy laws treat this with a lot of caution, because, as I said, the technological advancement has a lot of implications on how personal data is used by automated profiling. So privacy laws are treating this with considerable attention, and there are specific data subject rights or other things in support of regulating the profiling activities. So I thought that is interesting to know, even from an HR perspective. Now, that brings us to the next question. Why should HR and payroll practitioners be concerned? Right. So the simple answer to that is that there is no human resources without humans in it. Right. So, and human is equal to, in legal terms, from privacy context, is data subject. So we collect significant amount of personal data as part of HR processes these days, that belong to real people, right? And this data, as you can see, if you can make out of the little pictures there, it includes things like biometric data, health information or banking information, education details, contact details, a lot of things that could fall into personal information bucket or sensitive information bucket. So that's why it becomes important for HR and payroll practitioners to be concerned about change in the landscape of privacy laws in Asia. Now, is that all? No. right? The HR and payroll systems and the technology and processes are becoming more complex these days. And when I say that, if we zoom in a little bit into that pattern, we would see that we can actually look into it by easily plotting the maturity and complexity of today's HR systems in an XY axis chart. So at the bottom left, at the least level of complexity and least level of maturity, you would see that there are quite intuitive, age-old traditional ways of handwritten and spreadsheet data being processed for HR and payroll with a lot of manual calculations and manual lodgements, etc. And one common theme that we see when we talk to prospects or talk to others is that in such cases the data will be stored in the local drive of the single or key individuals who are running these processes. So that obviously lies at the bottom left of this chart. And then you would see, if you move a little bit further up and right, you would see there are a little bit more mature and complex systems where the data is largely digitized, but still living on spreadsheets. And there are payroll systems, and often we see that these are legacy payroll systems that do certain things very well, but then maybe not all the things that you need to run payroll. And for the reason it being a legacy system, the support and the technology platforms are the support is going to be minimal for the application, and in some cases even the technology platforms used for that application. And data storage slightly is better. It is perhaps hosted in what can be called as a data center, but again it could be locally managed, or it could be in the control of the organization whose payroll system is being hosted. Now, what if we move further right and up to one of modern day systems? It gets quite complex there, right? And one of the hallmarks of modern systems and HR and payroll ecosystem that I see a lot these days include three elements, I would say. One is a centralized HR system, a lot of times in the cloud, which means that the data could be transferred across borders a lot. And then you would see that if it's a multi-country setup, you may see multiple payroll engines per country or groups of countries, and they are generally advanced, and they are quite powerful to perform a large set of calculations that you would require. And also the interaction of information between these systems happen through interfaces which are like middleware. And also if you can throw in, if there is a multi-country arrangement or even in single country arrangements, you can throw in one or many providers who would process the payroll. So that's a complex system. Now I want to zoom in a little bit more into the top right of this chart to come to this, right? And see, well, they say the devil is in the details, right? When I created this slide, I thought it looked a little bit too busy and complex. But then I realized that it's not a bad idea to make something complex and busy to describe any IT system today, right? Any corporate IT system today, and all the more the HR systems. So uh, if we just quickly look at it, it can be put into distinct phases. So a lot of personal information is collected directly from the employees through the onboarding process, and also through their uh, employment with or association with the organization. So when they are joining the organization, we may collect information about their education, banking details, their health information in some cases, a lot of information basically, right? And a lot of data is generated as they go through their association with the organization. So time and attendance data can be captured. There may be performance related information that is captured, etc. And as we saw in the previous slide, in a modern system, generally there is a global HRIS that where the focus is mostly to give an very intuitive and consistent user experience to the employees and the operators of those systems, regardless of the country or the department that they work on. And that system, if it works well, would also be able to interact with other payroll softwares, which nowadays we see a trend of payroll software being separate from HRIS a lot, and they do the best that both of them can individually, and they are interfaced with the help of a middleware. And you will see complex relationships between multiple outsource providers or further levels of subcontracting, and also a lot of third parties like statutory or financial institutions, clearing houses or benefit providers, etc., interacting with different elements in this process. Why do we have such a complex slide? It is to show when a privacy expert looks at something like the top right corner of the previous chart, this is what goes in their mind. I mean, the kind of data flows that could be there, the kind of endpoints that could be there, and the risks associated with that, right? So now, this means that privacy is a really real concern in modern HR and payroll departments. We handle a lot of personal information, and it should be done in a compliant way to the Privacy Act, and also being ethically responsible to the individuals whose data is being collected. So there is no question about that. But from an executive's point of view, from a leader's point of view, with all such investment to cutting edge technology, it's quite natural for an executive to think like, well, I have invested so much on HR technology and I have the best IT guys in my company, which I'm proud of. It must be keeping the data secure, wouldn't it? But is that really the case? Let's look into that a little bit, right? So privacy and security, aren't they the same, or are they? So it's very simple. I mean, let's just cut to the bone right away. Organizations cannot simply rely on security alone to meet all obligations under privacy laws. Okay, so let's put that on the table as a start. So view it like this, right? So privacy is about the fundamental human right of natural persons, which is very much a legal matter, right? And you can say that it's a legal and ethical matter. But security is about protecting the data from breaches of confidentiality, integrity, or availability. So, in other words, the best security system in the world alone will not guarantee that there is compliance to privacy laws. However, it is essential. It is so essential that in today's world, without effective security establishments, it will be practically impossible to achieve privacy. However, it's important to understand that security is not equal to privacy. No matter how important and how critical security is to achieving privacy. Okay, so now I think the context is set a little bit to understand privacy, the difference, and why it is important for HR, and how it is different from security, but so much reliant on security. Let's move into the interesting topic for the day. Let's talk about Asia. So, in when we talk about Asia, first and foremost, the interesting thing is that the privacy laws in Asia and Australia, I would say, are going through a period of significant changes. You can expect this to continue for some more time, based on what we hear from the governments, from the regulators, and from experts in the industry. And while APEC privacy framework has been in existence for some time, it's not a directly applicable regulation, unlike GDPR. And when we say that in Europe, one of the challenges before GDPR was enforced was that there was a directive for data privacy, data protection, and that directive was in a way like a framework that was non-binding. But the GDPR is a regulation, which means that every member state, it becomes the regulation, or it becomes the law without them passing independent laws in support of it or different from it. So that standardizes the requirements across the union. But the APEC privacy framework is not like that. It is more of a sort of a directive, and it does not displace or override any country's domestic laws and regulations. Right. So that's an interesting space which allows for a lot of diversity. And then if we talk about the third point, I mean, it won't be Asia if we didn't have that third point there, right? So anybody, I mean, all of us, I hope, are working in HR and payroll profession, directly or indirectly. And if we try to run regional payroll, one of the things that we would have run into as a challenge is that a lot of laws related to labor, HR, and payroll is only available in the local legislation. And that is not very different in case of privacy and data protection. A lot of information is only available in local legislation. So that's what it makes things interesting in Asia, generally speaking. And let's some examples for this, right? So you may have guessed already, this can't be an exhaustive list of privacy changes in Asia, but I think these fit in nicely for today's themes and represent, more importantly, it represents the evolution of privacy and data protection legislation in Asia and the direction that it's taking quite well. Uh, so I mean, to be honest, as I said, it is, as a privacy professional, it's quite an interesting and exciting time to be in Asia. If I speak on my own behalf, and I mean, I always feel thank goodness for governments; they keep me employed and in demand, right? So it's going through a series of dynamic changes. So let's look at some examples. One, the first thing, I mean, I would like to say that the giants are waking up finally. We are seeing rapid changes in privacy and data protection laws and regulations in China. And also, India has been working on a draft personal data protection bill. The draft is available publicly now for some time. So, both of these have already drawn comparisons to GDPR, and as they get refined, I would say a good example is China. When this the new wave of changes in China's privacy, security, and data protection legislation and standards started, uh, the focus was initially more on the security aspect of the data, like protection of the data. But then there are clear indications when I look into the news coming up from China, from the horse's mouth, actually, we can really see that the direction is clearly going to be focusing on privacy as well to a large degree. And I mean, can't really think India would be much different because I see a lot of kind of questions being asked by the Supreme Court and the government responding to that about privacy as a human right in general. So quite interesting times in India and China, I would say. And Malaysia, I mean, some interesting news in Malaysia. I mean, incidentally, I'm based out of Kuala Lumpur, so it makes sense to put that in. I know of one press release where the minister was clearly uh, implying that he was looking into definitely the GDPR, and everybody can expect revisions of Malaysian privacy acts sooner than later. And it's at least expected that there will be some measures taken to, I mean, that you could say is inspired from GDPR. And then Thailand introduced the PDPA for the first time, and it was ascended to the Royal Gazette in May this year. Uh, and it has many concepts similar to GDPR. Like, it introduces the concepts of data controllers and processors, and it sets obligations for each very clearly. And also, it establishes clear rights for data subjects. So I mean, from this, you can see that the privacy laws are changing, evolving in Asia, and they have some common themes of development, or taking a common direction in terms of where it is getting. So you can see that generally a lot of focus is being placed on privacy as a human right and enhancing the power of individuals or citizens, or whatever you want, human beings in general, to kind of dictate or control how their data is being collected and used, which I would say is a good thing to happen, and that's what it should be. Now, the elephant in the room, right? So, no privacy or data protection discussion is complete these days without talking about the European Union GDPR. So let's see what Asian authorities think about GDPR. So I was looking to see if I can find some information on what different regulators or governments think about GDPR in Asia. And I found some interesting things. So without boring you by reading all of that, I think the first 2 points there, respectively from the privacy commissioners in Singapore and Australia's websites, it is a recognition that even if organization in Singapore and Australia respectively, GDPR may be applicable under certain conditions and criteria, and organizations shall take steps to ensure that personal data handling practices comply with GDPR, even if you think that your practices are currently compliant to the law of the land, like the privacy law in Singapore or Australia respectively. and it's no different in other countries. It's just that I managed to find two quotes rather quickly when I was looking for it, so I put them there. Now, the third one is interesting. This is a little bit old. This happened in mid 2017. This was a joint declaration by the Japanese Prime Minister and also the President of European Commission, back, as I said, mid of 2017. Uh, Expressing a formal interest in getting into an data transfer adequacy decision mutually between European Union and Japan. And it was said mid of July 2017. I would say the goal was quite an aggressive one to do that by in 6 months rather. But then eventually early this year there was a formal signature of this adequacy decision by both parties, and that created the world's largest area of safe data flows. A very significant event in the view of somebody who is a privacy practitioner in Asia Pacific. And what I think that point is important is to show that the government in the region is quite keen to get that adequacy decision, and that means with European Union, and that means making changes or bringing in additional standards and regulations on top of existing privacy laws in these countries. So we can expect this trend to continue, and we can expect understanding of GDPR or developing an understanding of GDPR at this point is going to help us all in during those days, I would say, in the near future. Okay, so what is the bottom line? The bottom line is the elephant in the room is real, even in Asia, right? So it makes us naturally want to understand GDPR a little bit more. And if I be really honest for something about GDPR, a lot of interest about GDPR, especially at the leadership level globally, was generated because of the hefty fines associated with GDPR. There are privacy laws which have very similar provisions to GDPR. They have been in existence for some time. There are privacy laws that are very strict with a lot of things, with specific requirements that sometimes I would say are equal to or overshadow in GDPR in a practical sense, even in Asia. But then the interest in GDPR was generated a lot because of the fines associated with it. So in the next slide, let's try to understand GDPR in the context of Asia in one page, right? So I'm trying to ask some questions that I think are relevant and trying to answer them because that seems to be suitable in this format. And in that process, understand GDPR a little bit better. But we are not trying to understand GDPR in 10,000 words here, but hopefully it helps us all to appreciate some key concepts. Okay, so first thing, it can't apply to us in Asia, can it? Right. So that's a very valid question, because it says European Union GDPR, and why would it apply to us in Asia or in Australia if somebody in Australia is attending? Interesting, because GDPR has scope clearly defined. So it has a material scope section, it has a territorial scope section, and just to say the least, it can apply to business entities or organizations operating outside European Union under certain conditions. So the first thing is, if there is a data controller and processor involved in the overall data processing activity, and if either party is based in European Union, then GDPR can be applicable. So, for example, if you are an Asian subsidiary of a European parent company, and there is a lot of HR employee data that is centralized in the Europe-based HRIS that get transferred to Asia or the other way around, etc., a lot of requirements in GDPR can become applicable. The second is the data subject is located in EU. And in both of these cases, the processing doesn't have to take place in EU. It can be in any country, anywhere in the world. But if these two conditions are met, then GDPR will be applicable. So it's the location or it's the residence of the data subject that matters in terms of GDPR application, as per the second point. And the third one is if an organization is trying to sell something or offer something like goods or services to data subjects based in European Union, then that would make the organization fall within the scope of GDPR. And very important to understand, such goods offering of goods and services doesn't have to be for a price. Even if it is a free service, if that is targeted to users in European Union, then uh, then the organization could be subject to GDPR. Right. Example is a company offering their products like a European web page with euro, accepting payment in euro, or a web page that is available, let's say in French, with product details there and a weight purchase from Europe, etc., would be seen as intention to offer goods or services to European Union, and thereby it would be in scope. And the next one is if behavior of data subjects like their location details, etc., or purchase patterns, shopping patterns, etc., are collected within the European Union. So the data subjects are within the European Union and their behavior is collected, then GDPR becomes applicable regardless of where the organization is based in. Then, what can we do to make sure that our data processing activities are lawful, provided GDPR may apply to us even if we are based in Asia? So the most important thing is that you need to make sure that processing of the data is lawful, or we call it as a legal basis for data processing. Sometimes there are 5 legal bases or lawful means that are allowed by GDPR. So one is the consent of the data subject. But there is a catch. The consent has to be freely given. It has to be specific. The data subject has to be informed about what they're giving consent for, and it has to be unambiguous. So it cannot be like consent by inaction. It has to be a positive consent that is unambiguous by the data subject. Why that is important? Because in HR context, a lot of times consent is relied upon singular basis for data processing, collection and processing, which can be questioned because a regulator might view that employer is naturally in a more powerful position when an employment contract is negotiated compared to the employee, and thereby consent may not be viewed as freely given. Second, HR processes nowadays, with the explosion in technology advancements, HR processes and the way data is used keeps changing. And if you have consent obtained, even if it is very specific at the time of obtaining that during the onboarding of the employee through a contract, things can change and you cannot go back to employees with another consent request like every other week to get consent for a new use of data that you have. So it is very difficult to rely on consent as the singular kind of basis for collecting and processing employee data, but it remains a very important aspect for consent for transferring data across borders under Asian privacy law. So consent is important, but it alone cannot be the basis for collecting and using employee data. The second could be to meet a legal or contractual requirement. So a legal requirement is obvious, but contractual requirement is actually a requirement between the data subject and the controller or the processor. Right. So an employment contract, and there is like a legitimate interest for the employer to pay the employee and the employee to receive such payment, etc. So for you can really use that as one of the legal basis for collecting and processing employee data under GDPR. And then the other two are quite generic. So you're protecting an individual like from harm's way, or you're doing it in public interest, etc. You can really process personal information. Now, what rights do data subjects have under GDPR? There are some data subject rights. I don't want to go through all of these, but it's very important that you look at your processes and your systems to make sure that these rights are respected, along with any additional requirements that you may have with the local legislation related to privacy. And one point, if I want to look at and elaborate on, is the right to erasure or right to be forgotten. That is one of the most dreaded, most or the least understood points among all of these. So it's like you have to make sure that you have the ability to erase or forget about an individual upon their request. But remember, this is not an absolute right? So somebody can request to erase their data, but it's not an absolute right. There may be legal reasons, there may be legitimate reasons why you have to keep such data. In that case, the request may not be honored, but you will have to really inform the individual why it cannot be honored and the reasons behind it, right? So, but why it is important to focus on. So you cannot erase somebody's data if you have to do it, like somebody who has left your organization 10 years back or 12 years back, if they want their data to be forgotten or erased. How can you do that if you do not know where this data is stored or what purposes this data is being used for? So right to erasure depends a lot on clarity on the data flows and the processes associated with it. So that's one point I would like to focus. I don't want to read through all of these points yet. Now, if we move further, right? Oh, okay. Sorry, GDPR and Asia in one more page. We have some more points that are worthwhile to discuss now. So what are the additional responsibilities under GDPR? So the responsibilities include, as I said, not an exhaustive list of all the requirements. There are two concepts called data protection by design and by default. If I can quickly explain those. By design means that you have to consider privacy and data protection as a significant requirement during every phase of design and development of a new process or a system or a new product that you offer to the market, etc. And by default means that you make sure that by default the highest level of privacy and data protection applies to a process or a system. That is, if you collect information, you collect only information that is sufficient for the purpose. A good example from Asia is, even though this concept may be the same words may be not used, there was a recent instruction or requirement that came out from Singapore, from the PDPC Singapore, about the use of NRICs. NRICs is a national identification card and number in Singapore, and the essence of the regulation is that NRIC should be collected and used only when it is absolutely necessary or it's actually required for the purpose of why it is being collected. And this was not the case before, right? And use of NRIC was quite prevalent. I mean, I remember visiting our like Singapore office or many other customers' places, etc. And the building reception asks for an NRIC. They note the number, and I'm told that a lot of loyalty club memberships would ask for NRIC, etc. Now, a lot of employers also use when they set up their database of employees, sometimes used NRIC as the employee ID. Now the question is, do you really need the employee ID to be the NRIC? You may need NRIC for other purposes like filing something with the government or the statutory filings, etc. But do you really need that to uniquely identify an employee? And the answer is unfortunately no, right? So the guideline basically says that you cannot use it unless it is really required, and that is nothing but an example of applying privacy by default. You do not need NRIC to uniquely identify a person in your HRIS, so do not use NRIC for that. You use a number that you generate for that purpose. Now, the next is a data protection impact assessment, which is also a requirement or a recommended practice under many Asia privacy laws. I will not go to the details of that, but it's critically important. It's critical to understand the data flows, as I mentioned earlier, and the data flows, the endpoints the data has, how it is processed, how secure it is established, wherever it is stored or used, etc. So that's quite critical. And then also designating a data protection officer may be a legal requirement, maybe really a requirement under GDPR. There are some conditions. I don't think a lot of Asian organizations would fall into needing a data protection officer in Europe. it may require, but remember, this is also a requirement under a lot of Asian privacy acts, right? So you have to have a data protection officer who would kind of give you the strategy and drive your organization in the right path. And they also have some responsibilities in terms of interacting with the privacy commissioner's office, like reporting things, etc. in Asia. Now, do we have to notify data breaches? Yes. In Asia, in Australia, they introduced the notifiable data breaches. I think, remember correctly, February 2018. Asia has such requirements in different countries, like Philippines, for example. But the criteria is generally the same. So when there is a data breach, it needs to be analyzed to see if there is potential of likely harm, serious harm or injury happening to the data subject whose data was breached, or is it going to affect the rights and freedoms of that individual significantly. If yes, it has to be notified. The time frame for notification, the ways and means could differ in different privacy acts. But if you look at GDPR, it says that it has to be notified to the data subject without undue delay, and to the supervisory authority without undue delay, but not later than 72 hours were feasible. If it is notified after 72 hours, you have to also include an explanation on why it took longer than 72 hours. And now last but not the least, as I said, one of the most talked about aspects of GDPR was the fines associated with it, right? So what happens if you fail to comply to this? And GDPR, I mean, assuming that GDPR is applicable in the first place, the fines could range between 10 million euros or up to 4% of the last preceding financial year's annual turnover worldwide, in parenthesis, whichever is higher. So that number is quite dreadful for organizations, as I said before. But then, I mean, you can always argue about what is the realistic likelihood of a European Union enforcer of GDPR applying such fines to an organization that's purely based in Asia. I wouldn't debate on that. I wouldn't express my opinions on that. But then this is what it could be. The regulators are empowered to establish or impose fines of this magnitude for violations in GDPR. Right. So that's, I think, what is very important to understand about GDPR in the context of Asia, and like how it relates to legislation in Asia, or how it differs from legislation in Asia. But then, in a way, the best and the most rational approach would be to view privacy and data protection not just from the viewpoint of the local legislation, but from the perspective of global best practices, while not missing out on specific requirements locally, like you have some registration requirements or you have some reporting requirements, etc. Why? Because in Asia, the legislation is evolving, and sooner than later, you would or you can expect these legislation to get more into respecting or imposing liabilities on data controllers and processors, things related to the fundamental right of privacy, and also more security impositions as technology threats evolve. So now, in the interest of time, if we try to wrap up, what are some watchouts for HR and payroll professionals? So the first and foremost, I would say the most important thing is know and document your data and process flows. When I say know and document, it is because documenting it is a specific requirement in some of the privacy acts. And knowing is very important because you cannot really negotiate or mitigate risks unless you know what are the risks to begin with. So very important to understand data is being collected, for what purpose, who is it used, how is it flowing, like to whom it is disclosed, and what are the endpoints where the data will reside. This is critical to know and critical to be able to enact requests that invoke data subject rights in modern privacy laws. Now, the second, remember, in HR, traditionally consent has been used as the sole legal basis for collecting and processing employee data. It may not stand the scrutiny as the only legal basis anymore. So it's important to look at the other legal basis that you can use for processing personal data and make sure that you have that clearly identified, understood, and applied. And very important to understand, privacy and security are in the same. So do not live under the please do not live under the impression that IT will breach proof HR. Now, then staff training is key, and in a lot of organizations, learning and development is seen as the part of HR, and it's very important to train the staff correctly and adequately. So, and it's not just sponsoring one employee or some employees from different departments to data privacy training and appointing them as DPOs or appointing one of them as DPOs. It is very important to make sure that anybody who directly or indirectly handles personal information is trained as well. Some interesting anecdote there. I was working for an leading security organization like close to a decade back, and some studies at that point showed that human errors were the leading cause of data breaches and security breaches. Recently, I read an article which said that direct cyber attacks are now the leading causes. So whatever is the true statement there, it's very important that security is critical for privacy, but it cannot guarantee privacy alone. And staff training is key. Employee awareness is key as far as data privacy is concerned. Then privacy laws may apply across borders. So please know your exposure and take the right actions. And very importantly, last but not the least, very importantly, remember you cannot outsource your risk in this area. You cannot think that I have outsourced my payroll process, so it is all the payroll provider's responsibility, or I have outsourced my recruitment process. It's all their responsibility to comply to the privacy laws in payroll or in recruitment. You cannot imagine that. However, you can always choose a service provider who understands the data processor obligations in context of global privacy laws very well and kind of practices that, and also who can help you to meet your obligations as a data controller. For example, you want to do a privacy impact assessment. You want to bring in the concept of privacy by design when you newly outsource to a provider. You need to have a provider who has understanding and the ability to support such activities to make sure that you have a successful relationship and you effectively mitigate the challenges and risk posed by exposure to privacy acts. So that sort of concludes. I mean, we can talk about this topic for hours and days at a stretch, but in the limited time that we have, that concludes my presentation today. I hope this helped you to understand the topic a little bit better, or at least appreciate the importance of understanding this topic and taking the right steps in your organizations. And with that hope, I would hand it over to Darren for some last words of wisdom. Over to you, Darren.
Thank you so much, Anij. Thank you for sharing with us. I think just being mindful of time, I have just two questions on my end that we normally receive from our clients. First question is, if I'm responsible for designing HR processes in my organization, what would be your recommendations to make sure that the data collected by us is of value to the organization and the employees?
Yeah, that's actually a very, very interesting question. It sounds quite simple on the face, but it's in a way complex to answer. So let me take the example of this privacy by default principle again. Right. So this is the concept of collecting what data is required for a purpose. So when you design an HR process for which you would need personal information naturally, you have to consider, okay, what are my current users and future users from this process? What is my expectation from this process? Am I collecting data that is really required for that process, and only to that extent? Like, I mean, in India, we have a saying that even medicine in excess becomes poison, right? So the same thing, I mean, just because, and there is always this affinity to collect more data, keep more data, and this kind of butterflies in the stomach when you delete data that really has served its purpose long back, etc. But then it's very important to do a privacy impact assessment and make sure that you only collect the data that is really required for the processes or the purpose that you would define. So that's an important process. The nuances could vary between organizations, but I would really recommend, if you haven't done so, I mean, for the person who's asking that question and for everybody generally, if you haven't done so, talk to your privacy officer if you have one, talk to your department if that lies within that function, to understand how to conduct a privacy impact assessment in your HR process, and make sure that you take the right steps to comply to the expectations of the privacy laws. Or if you have an outsourced provider and you want to talk to them to understand how the data is used by them. Yeah, I mean,
Thank you,
hopefully
Anij.
that answers it.
Sure. Second question, this data protection by design and default concepts are quite new to me. Can you please elaborate on this in context of HR processes?
Yeah, okay. So I think I talked a little bit about data privacy, data protection by default as part of the previous question. But again, just to paraphrase or reiterate, it is making sure that, put in layman terms, the highest level of privacy requirements should apply by default, and data subjects should take the decision to reduce it. It should be their willing decision, right? So, and that also means that you only collect and use personal information to the extent it is required for the purpose that is agreed by the data subject, if you rely on consent, etc. So we can apply that to the HR context in various ways, as I explained before. And then finally, talking about privacy by design, it is exactly what it says. It basically means that privacy or data protection by design, data protection should be a consideration throughout the design and development lifecycle of a product or a service or a business process, even if it is an internal process or an external process, as long as it handles personal information. It cannot be an afterthought to a finished product anymore, and measures and like fail-safe mechanisms, etc., should be checkpoints, etc., should be applied in processes from the start of designing the process. For example, encryption requirements, password requirements, or data anonymization requirements, or even generally the extent to which data is shared between systems, etc. That should be considered during the design. And it's important, as I said, if you are, let's say, you are outsourcing payroll process or recruitment process, when you design that shared solution between the provider and the customer, you should really consider that as a designing activity and keep privacy and data protection in mind while doing that. Hopefully that answers it.
Thank you, Anij. I'm still seeing a whole list of questions from all the attendees today. I know, but due to time constraint, I don't think we're able to answer every single one of them. But we will be, contacting you separately after the webinar to answer your questions. So I think that's the end of our webinar. Thank you, everyone, for your time. If you have any questions, do feel free to email us at hello@accenturehcm.com and we'll respond to you. Lastly, thank you, Anij, and everyone for attending. Be sure to look out for our next webinar. Have a great afternoon. Thank you.
Thanks, everyone.